all for attending today's USA Gymnastics Member Club Advocacy Webinar with John Valencia, and we also have today our Club Services Director, Lorraine Gallimore. So Lorraine will speak to you all. We are specifically targeting our New York Gymnastics member clubs. So today this is the webinar that's specifically tailored to you all. Lorraine.
Thank you, Lakeisha. Welcome, member clubs, our expert John Valencia, and our state chair, Tina. We appreciate you taking the time to come together. A club owner in New York has brought something to our attention, and as we hear from a club owner, we want to pull together the network of club owners and see how we can help facilitate a situation. Throughout the country, we've got 10 states with different types of issues. We've helped out a few states recently by doing webinars like this for their state, and it's been very helpful. So we hope this is a helpful webinar for you to gain some information on some of the legislation going on in New York in situations that you might be hearing of, and that you can get together as a network and work through these issues. We have an expert who's been great education for us and is helping us guide us through this process, Mr. John Valencia. John?
Good morning, Lorraine. Thank you very much, and good morning all from the West Coast, and an early good afternoon to all of you in New York. My name is John Valencia. I'm a partner in the Sacramento, California law and lobbying firm of Wilkie Fleury. This is our 93rd year in practice, and I have been a legislative advocate or lobbyist for nearly 30 years, representing a variety of professions, businesses, and organizations, including Region 1 USA Gymnastics for over the last 3 years, now approaching 4 years in duration. As Lorraine mentioned, businesses, which at the end of the day is what your gymnastics clubs are encountering different issues around the country, whether they are forms of regulation as proposed regulation as daycare centers, whether there are physical accommodations being required, whether there are tax obligations that may or may not be well known to this particular industry segment. Clubs are becoming aware of these issues, either through consumer complaint, regulatory agency inquiry, an awareness of ongoing or existing legislation or statute, ongoing legislation and existing statute, and want to take steps to respond to that. That is essentially, as Lorraine has mentioned, what developed in New York. It has come to the attention of USA Gymnastics, which wanted to respond to the circumstance that your Attorney General is focused on gymnastics clubs and other business operations, all of which fall into a very broad spectrum, a very broad definition of a long-standing law, the Health Club Services Act in New York. This will be a brief outline of what is required and an outline of steps that are available to you if you'd like to make a difference in the existing circumstances in New York. First slide. So as we mentioned, here's the issue. Your New York Attorney General, Eric Schneiderman, wants you to comply with the New York Club Services Act. This is not a new statute. It's been around for any number of years. It has broad definitions. It has a requirement that health clubs with only a very few defined exceptions are required to file a certificate of deposit, a letter of credit, or a bond with the New York Department of State. The Act has very prescriptive minimum specifications for contracts between clubs and clients, which may come as a surprise to those in the business who perhaps have a handshake for a contract, among other potential risks. And excuse me, New York USA Gymnastics member clubs and their professional athletic training services have, as we mentioned, are hearing from the New York Attorney General office that the law, in their view, actually applies to gymnastics clubs. Next slide. Next slide. Okay, there we go. So here's that broad definition we were talking about. And I've highlighted the key provisions that are being used to apply to gymnastics clubs. Health clubs means any person, firm, corporation, partnership, unincorporated association, or other business enterprise. Key phrase, offering instruction, training, or assistance or the facilities for the preservation, maintenance, encouragement, or development of physical fitness or well-being. It's a very broadly drafted definition, and if you stopped right there, you would be hard-pressed to see any exception for the particular and unique sector of athletic instruction and gymnastic skills. But then the statute goes on to say, such terms shall include but shall not be limited to sports, gymnasiums, for which there's no separate definition, and any other setting in which there is a similar course of physical training. Two broad segments in this definition. We'll get to very specific carve-outs for specific classes of business models, which, given the current posture of the Attorney General in New York, does not appear to apply to gymnastics clubs in the state. Next slide, please. The law, as we mentioned, requires financial filings with the New York Department of State in the form of a bond and irrevocable letter of credit or a CD in favor of the state of New York. We'll go through the prescriptive minimum specifications for contracts. And I wanted to point out that this is not a statute, now that it has come to the attention of member clubs and the vast number of businesses that are subject to this statute. It has a very, very negative, very bad private enforcement provision. This private enforcement provision, beyond the state's attorney general, a government official, this provision in the statute allows private plaintiffs' attorneys to sue what they would allege would be non-compliant clubs. Successful plaintiffs can win up to triple the damages suffered by their clients, and that's money out of your pocket or potentially your insurer. I'll leave that to you and your insurance coverage to make that determination. And horribly enough, recover their attorney's fees. That is, the plaintiff wins, you lose, you not only pay their plaintiff client, you also have the privilege of paying for the attorney's fees if they should succeed. So simply stated, a losing club pays the court-approved claim and pays the plaintiff's lawyer's fees. And in some cases, those fees, which can be ginned up by the hour, especially in a fairly high-cost state of New York, just like in California, those amounts may actually dwarf the actual payment. There's a reason this provision is called the private bounty hunter provision. So the general business law requires that health clubs or spas file these financial documents in favor of the state of New York. You'll be able to cut and paste the link in this slide that will take you directly to the form and the steps outlined for filing the financial document and the financial security in favor of the state of New York in the event that there are certain specified developments relating to your business, client cancellation, business closure, and so forth. Next. Here's what it requires. The bond, letter or credit, or certificate of deposit is $50,000 for club selling services contracts. The contract is defined as one of 12 months or less. $75,000 if your club is in the business of selling professional services, that is gymnastics instruction services, contracts of between 1 year and 2 years, and $150,000 for clubs selling contracts between 2 years and 3 years. Clubs with 3 or more locations then are obligated to add the additional following amounts: $50,000 for 3 to 4, $100,000 for 5 to 6, and so on up until you hit the point of 10 or more locations for your business operations. As I mentioned, the contracts are pretty prescriptive, and this comes straight from the statute. Every contract for services, which means there has to be one in existence, can be canceled within 3 business days after date of the receipt by the buyer, that is your client, of a copy of the written contract. So that may not actually be 3 business days after you sign them up. It could actually be an extension if you sign someone up for services on, say, a Friday. Saturday and Sunday don't constitute business days. They get the contract, let's say, in the mail the following week. You can see that the way the statute is defined, there is a significant extension of the time period involved. And you have to tell clients, customers, that they have a right to cancel with the following specific language, and the obligation to print it comes straight out of the statute, even to the point of specifying the size type and the fact that it has to be bolded. Contracts also have to contain additional language, also specified as to typeface and bolding, additional rights relating to cancellation. There are a series of circumstances in which customers, clients, can cancel or would have their arrangement with your gymnastics club canceled. Doctor's orders, death of the client and the estate seeking to get out of the contract arrangement. The client moves away from any health club, any gymnastics club, and sorry, I've used the exact language out of the statute, but of course now we know that health club is synonymous, at least at present in New York State, with gymnastics clubs. 25 miles from any health club operated by you, the business operator. Services cease to be offered. You get out of the specific business of gymnastics instruction or close your business outright. And any cancellation that may be disputed that is not disputed, as specified in this particular language, has to be refunded within 15 days of receipt of the notice of cancellation. So as I mentioned, and I'll say several times, very prescriptive, very obligatory and specific language that has to be followed by a business defined as a health club in New York. Oh, there's one more thing. Added to the statute in fairly recent years is an obligation to have an automated external defibrillator. You can cut and paste the link to go to the full statement. This is a bit of a modified Good Samaritan law that you will find. First and foremost, businesses that meet the specifications of the statute have to maintain the existence on site of an AED, as they're called, automated external defibrillator. This requires a very careful reading of the statute. Again, like many laws that good people try and comply with, it isn't exactly clear on its face, and unfortunately it may be that you'll need to turn to New York counsel that advise your individual businesses around the state as to whether or not the successful nature of your business operations constitute a membership sufficient to qualify you for having to comply with the statute. So not only your own careful reading, but quite possibly the assistance of a New York State professional. I am not registered there, and this is not legal advice. But this is an obligation that was added into the health club statute. On the plus side, at the conclusion of the presentation, USA Gymnastics will share with you information on discounted acquisition of the equipment as you move forward and determine that you may be subject to the statute. And of course, we've touched briefly on one portion of enforcement for violations. Any seller or any of your operatives who may violate any provision of this statute are subject to the private bounty hunter provision of up to $2,500 for each violation. And each violation may range from every aspect of the statute that's violated within a single contract times all the contracts that you now know have to be in place unless and until the provisions of the statute may change. In addition, should the public agency, the Attorney General or some other public law enforcement agency move forward, they may, although I think it's unlikely, but that's a personal opinion, they may pursue a violation as a criminal misdemeanor. There is a very broad supplement to the enforcement provisions, again underscoring that this is a statute to take in all seriousness, that in addition to all other remedies the Attorney General may have available to him or her, he or she may pursue such other relief as may be appropriate. Now, the plus side of language like that is that there can be private negotiations for how to come into compliance with the statute, especially if you come to the relatively new realization that it applies to gymnastics clubs in New York. This is also required reading because New York law says that it is so, and as we've touched on, really it's something that can only be ignored at your peril as a business person in the state of New York. the law specifically obligates licensees or those who are supposed to be licensees to understand the health club services law in New York State. Again, there is a fairly straightforward recitation of those obligations brought to you by your governor and by your Secretary of State. Cut and paste the link. It shouldn't take much more than about 15 minutes worth of reading to catch up on a full slate of the obligations of health clubs in New York State. What changed? Well, that's difficult to say. I'm not sure from afar that anything changed. It's fairly clear that the statute's been around for a long time. The application of this law to gymnastics clubs, if it didn't occur before or we didn't know about it, may have come about for any number of reasons. I don't know that there's any one central reason other than there's been a bit of a light bulb moment in the state of New York where the Attorney General says, aha, these business operations look to us like health clubs as well. We haven't paid attention to them before. But a few of the factors could be the state needs more money, and when the state needs more money, they typically go out and look to sanction businesses that they can fairly readily identify are not compliant with often confusing and very long-winded statutes. There might have been, we don't know, there might have been any number of outlier clubs, we'll call them charitably, across the spectrum of the businesses that are licensed or required to be compliant with the Health Club Services Act in New York that the Attorney General began warranting action. That typically comes about as a result of consumer complaints and an assessment of the businesses. And frankly, the more successful the business, the more folks that you deal with, the greater your visibility, your size, success. It just could have been a turn in the barrel. It's very difficult to say, but one thing we know is that the statute hasn't changed in quite some time. And of course, while neither the Attorney General nor the Governor appear to be up for re-election this election cycle, 2016 being a presidential election year, they're not up until 2018. PR is what we all should know is politicians' catnip. These are, the next couple of slides are quick examples of the sort of media that has appeared in the state of New York. You may very well have read it, or you may have ignored these kinds of articles believing that the Attorney General was talking about someone else, other businesses. Gosh, we're not a health club. We don't take memberships. We don't have weights. We don't offer weight loss discounts and so forth. But no, in fact, because a number of your colleagues were swept up in this review and this announcement, in fact, these articles warrant a careful reread because this, at the end of the day, is what resulted. Next slide. Here's another example, and the article below listed this link generated by CBS New York. It does not list specific clubs across the spectrum of businesses that were snagged by this nearly 100, the actual number being 96, series of settlements, but you can cut and paste this link to determine just how geographically pervasive and diversified the operation was by the Attorney General. So the current state of affairs is unquestionably your New York Attorney General has concluded that this particular statute applies to USA Gymnastics club operations along with many, many other types of businesses beyond the specter of USA Gymnastics club operations in New York. And it is very probable that every New York USA Gymnastics club or any gymnastics club, even those not affiliated with USA Gymnastics, could face the likelihood of having to secure at least some level of additional legal professional services locally to make sure that you examine the statute and determine how much, if any of it, applies to your business operations. And also, you'll probably need to seek out some professional accounting services to ensure that you assess how properly to comply with the financial filing obligations under the statute, should you make the determination that this statute applies to you. This is a redacted example of the kind of communications that are received by those that are identified by the Attorney General. It can be alarming. It should be taken seriously should a document like this show up in your place of operation. And as you can see, and I apologize for the quality of the copy, but it says in point of fact and on official New York State letterhead an outline of the provisions that we've talked about preceding. So this is just an example of something to keep an eye out for. And typically it's signed by an Associate Attorney General. So your options at present, aside from an initial assessment of applicability of the statute to your business operations and what degree of compliance is required, you have options moving forward to gain clarity or to determine as a coalition, and a mighty coalition at least available to you in the state of New York, of clubs that collectivize to make a change in the statute, make a change in the policy. It's pretty clear that the New York Attorney General at present can't distinguish between training Olympic champions and general weight loss fitness businesses. As you've seen from the statute that we reviewed before, it is a very broadly stated statute, big enough that you can drive any number of business trucks through it. Conversely, the Attorney General could read that statute as not applying to the specific nature of the business that you're in. But at present, gymnastics clubs look to the Attorney General like all the other businesses that are subject to the Health Club Services Act in the state of New York. So it'll be up to the clubs, if you activate on this measure, to get together and begin contemplating how to approach the Attorney General. But be honest with yourselves. Let's take a look at item B. Are there enough similarities in the way that the 150 plus USA gymnastics member clubs in the state of New York operate? Or are you so dissimilar, and are your business operations so dissimilar that some clubs do, in fact, clearly fall into the way the statute exists now? I can tell from the questions popping up that there are a variety of different business operations around the state. Before moving forward, as the old Saturday Night Live skit said, talk amongst yourselves first, in order to determine if there are enough similarities to move forward on a common basis in terms of business operations that could lead to an exemption for gymnastics clubs in the state of New York. Conversely, if you come up after talking amongst yourselves with too many no's, and there's not a way to standardize business operations in relation to clients in the state of New York, it could be much simpler simply to focus on changing the policy. And some of your colleagues have already established contacts with members of the New York State Legislature, outlining the problem and perhaps teeing up the platform to move forward with a change in statute. In the history of the state's law, it's important to know that it had a reason for coming about. But clubs really, gymnastics clubs, especially those that are affiliated with United States Gymnastics, USA Gymnastics, really weren't the rationale for why this statute came into existence. What I've reprinted below is what's called legislative findings and declarations. This appears in the statute as the reason why the New York legislature back in the day, and ultimately the governor of the day, opted to try and protect consumers from certain business practices that might be best known in traditional health club arenas. Money for weight loss, limited membership, long memberships much to the surprise of customers, and so forth. But really, the positive aspect of this statute is that it's supposed to safeguard the ethical health club industry, which clearly we strongly believe include USA Gymnastics member clubs in the state of New York, to the extent that you would even be regarded as a health club operator. The awful practices that brought this statute about clearly I think everyone on this webinar today and USA Gymnastics would certainly agree, would not brought about by USA Gymnastics member clubs that subscribe to very high ethical and professional standards. In fact, this statute should be about protecting your business operations, and that's a key element to raise in any discussion with public policymakers to say, we're not the reason this statute exists. This is the way we operate. Please help us as businesses in the state of New York not to have to deal with something that was never intended for our business sector to begin with. If the New York Attorney General can't, due to an identified lack of statutory authority, although it is a very broad and somewhat vaguely worded statute, or won't, because he or she has no political will to do so, issue a helpful, clarifying interpretation of this statute that has the net effect of either exempting gymnastics clubs, or a decent fallback could be to deprioritize its enforcement against New York USA Gymnastics member clubs. In all likelihood, it will probably be necessary to seek legislation that spells out a very precise exemption for most gymnastics clubs operating in New York. I put in parentheses, may not be all. This goes back to the earlier slide of the need to get together amongst yourselves, find out how much uniformity there is in your business operations, identify that which isn't uniform, and see how much of it is necessary to the businesses that have different business operations, or whether or not there can be some level of standardization in the relationship between your unique business sector in gymnastics sports instruction and health clubs generally. There is strength in the incredible numbers that you have in New York. New York USA Gymnastics members number in excess of 150. You have well over 1,000 professional members. You work with well over 6,000 athletes, and there are nearly 150 USA Gymnastics sanctioned competitions and activities in the state of New York. That's an incredible presence, and you're going to need to bring that to bear because at present, as I note, under the existing interpretation of this statute, it's not a matter of if, but more likely when the New York Attorney General or some private bounty hunter comes along with the idea of enforcing compliance with this statute. There will be, I see, a clear need for USA Gymnastics member clubs to align with one another and seek some change in the existing circumstances. First things first, let's get to know one another. The modern era of cyber communications and the internet and email, tweets and Twitters should help you convene. Plus, there is a standing ready list of those that you don't know, although as big as the business sector is in the state of New York, I'm willing to bet that many of you know one another. Leaders will emerge. It's important to create an inventory of who knows who in New York government. You'll be amazed and surprised how many brothers, sisters, wives, cousins, aunts, uncles, down to the street neighbors are in the legislature or in the Cuomo administration that may be able to see the reasonableness of a slight change in this statute or a different interpretation in the existing statute so that it doesn't quite so negatively impact member clubs in the state. You'll have to secure the maximum participation of member clubs around the state. If you don't, no one is going to resolve or address this issue for you. And of course, you'll need to organize. You are, at the end of the day, all volunteers for one another, but you'll need to marshal and coordinate efforts so that the entire huge state, both geographically and by population of New York, north, south, east, and west, has some point of contact for your ad hoc organization to move forward with change. Once you're organized, leaders working with the members as a whole should frame up, and I expect that you'll probably, at least in this instance, may want to call on New York State Legal Counsel to help with the framing, although you want it to be in plain business club owner English. A letter to the New York Attorney General. Outline the problem. And in outlining the problem, ask for a meeting with a representative number of the leaders that you've organized around to go just talk person to person about the nature of the problem, including a fact sheet which USA Gymnastics has generated about the significance of the industry and the sport to the state of New York and the number of champions that have emerged. But really what this would be about is the central issue of distinguishing the unique business that athletic instruction, gymnastics training, and sports instruction is compared to the reason this law came about to begin with. After a reasonable amount of time and calls to cement that appointment, particularly if you've made it, you'll want to publicize your efforts in positive terms. And if you've been rejected in your effort, then I'll leave it to you to conclude what the alternative is. Social media and traditional media are your allies. Recognize that the Attorney General, as a skilled politician like most of them around the country, has the capacity to push back. And there is some risk of being demonized, but if you stick to your guns, talk about the unique nature of the business that you're in, rely on your fact sheet about why you are different from the businesses that may have brought about this act to begin with. If you simply stick to that messaging, that will distinguish you from any sort of media pushback. Not a guarantee you will get it, but you are who you are. Eventually, if you seek legislative change and cooperation in changing this statute, every member of the New York legislature is going to have a vote at some point or another. And each one of them, whether in your House of Representatives, State Assembly, or in your State Senate, represents one of you and those of you amongst your colleagues that are not currently on the webinar. And about a third of the membership in New York State, we understand, is attending. You'll want to keep this potential ally, these potential allies, your one assembly member and your one senator, absolutely informed of what's going on and why you'll need their assistance. Next, okay. Eventually, you're going to want to take the issue local in a place that is likely to be sympathetic to the plight of gymnastics clubs being reeled in with weight training clubs, weight loss programs, and so forth, in a manner that doesn't recognize the Olympic and national champions and competitive athletes that you're trying to produce. So you'll want to turn to those who know you best. You may actually even advertise in local newspapers, in local Chamber of Commerce newsletters, in anything that is available to you locally. You are strongest where you are best known. And just simply report what is occurring and what it is you're trying to change. Don't stop there. Take every opportunity to publish a simple, consistent message in anything that your clients might understand so that the family members and the club members understand exactly what's going on. Then make your local legislative district office appointment as soon as possible. With each club legislator, each member of the Assembly, and each member of the Senate that represents any one of the 150 plus members of the New York United States Gymnastics Affiliates clubs, and simply mention what it is, the steps that you're taking to try and bring about a change, that the statute has lost focus in terms of its enforcement and now seems to be trained on businesses that never created the need for it in the first place. Keep it positive, focus on that lost focus and its capacity to produce technical violations and settlement headlines. We've already seen examples of that really don't do anything to protect your clients, your customers, your athletes, but really was intended to help casual health club memberships, gym in the traditional meaning of workout gym memberships and so forth, and that there is a need to relieve your unique business segments from the very significant financial requirements created by this statute, as well as the compliance requirements that may lead to violations that could cost you a significant amount of money. So about that meeting, well, here's how to get a hold of your Attorney General. Under a coalition bannerhead, you'll want to reach out. This is, at the end of the day, an elected official that runs regularly for repeat recognition in your state. ostensibly to be responsive to those of you who are resident in the state of New York, voters and business operators, in a key business segment that does tremendously by the state of New York. That is the fact and data set that's contained in your USA Gymnastics Prepared Fact Sheet. And you need to know a bit, if you don't already, about who your Attorney General is. All of this information that I've repeated in this condensed slide is available through the magic of internet research, general publications, stories over the years, and remarkably enough, much of it comes directly from the Attorney General's official biography on his own website. I think you'll want to keep in mind that this is someone who professes to be for everyday New Yorkers, and I imagine everyone regards yourselves on the line as everyday New Yorkers who do in fact work hard and try and play by the rules. If you know what the rules are and when they do and don't apply to you, and in an instance where a statute came about for reasons other than your business operations, you believe that this shouldn't apply to you. Next. Don't be surprised, of course, if the meeting doesn't produce immediate results in the form of that recommended reinterpretation of what is or isn't a health club in the state of New York. If you don't get it right away, please ensure that you set about getting a tight timeline for a final decision from the Attorney General that your gymnastics clubs didn't create the need for the law and can be viewed as either not covered by the law outright based on an interpretation of some very vague and broadly stated language, or at a minimum that the Attorney General will stand down and deprioritize enforcing the statute for those gymnastics clubs, if I were in his chair, that meet certain minimum standardized requirements. And that is a bit of negotiation that can and should take place with your New York State Attorney General, with you as significant business operations in that state. You'll need to think about enlisting other allies. This list could be very long, but one that popped out in some general research about business and legislative activities in the state of New York is the Business Council of New York, which states that 72% of its members are small businesses. Some members online may already be members or affiliated with the Business Council of New York, but they are a professional advocacy organization in Albany where you will need some help and some guidance and some alliance. Should you come up with legislation to make a very straightforward change to minimize the reach of this statute or generate a carve-out entirely, you very, very, very much will need to shoot for 100% member club participation. Quite simply, as I've stated before, no one's going to do this for you. You'll need to be in touch, and everyone has something that they can do. These are just a few examples. Some business people will be more capable of spending time on the effort to bring about change. Others, for whatever reason, may have limited time or limited capability. That at a minimum, everyone can write a letter in support of a reform bill if you come up with that. Next possible activity, since it's very much a local activity, would be to meet with one's own legislator, one senator and one representative per club throughout the entirety of the state of New York with 150 plus member clubs, and I imagine this issue may even generate more future affiliates, so you could very well grow as a consequence. Should there be actual legislation, you will want to organize amongst yourselves to ensure that there is a face that is you as business people on this issue. And club and coalition representatives need to appear at every hearing scheduled for a reform bill to put a human face and a local business presence on the issue. It's not businesses seeking an escape hatch or a carve-out without good reason, and that good reason is we didn't bring about the need for this statute to begin with, and there's never been an identified crisis or scandal involving us in the way that there have been perhaps other businesses that did bring about the reason for the statute to begin with. Local media, again, is your friend. Some people may be savvier and more inclined to want to reach out, but this is another opportunity for activism and activation on the part of member clubs in the state of New York. And every governor has a legislative deputy working for him or her that is responsible for advising on specific topic legislation. This will be the Health Club Services Act in the general business world of the state of New York. There is a legislative deputy. A simple call to the governor's office, legislative unit can identify who that is. You'll want to keep that individual apprised of every step along the way on the proposed measure. Should you succeed in pushing a measure all the way through the legislative process, it's conceivable that in addition to signing that change for good, there might be a gubernatorial veto. Know that you'll need to keep the activism going because, as we said, every member of your legislature could have a vote on this reform measure should you decide to proceed with it, and gubernatorial veto overrides take a supermajority, 2/3 vote in both your state assembly and in your state senate. And it's remarkable how large your legislature is, 150 assembly or House members, 63 senators. That's a fair number of folks, but if you break it down to one senator and one representative per club, it's a manageable number. There is one last potential resource, and it is speculative on my part, but someone local to New York City will need to call a City of New York business solutions agency to see if it can in any way assist with this activity. It is a creature of New York City government. It's principally oriented to helping small businesses, which many of you are, figure out the intricacies and ins and outs of compliance, permits, licensing, and so forth, not only within the state of New York, but not only within the city of New York City, but in the state of New York generally. There's a new initiative called Small Business First to, quote unquote, improve the regulatory climate in New York City. Well, a change in this area would go a long way towards that. Seek out a representative of the program, have a sit down, at a minimum a phone call, identify the problem, and see if there's any way that the organization and agency can be enlisted as an ally for changes in the Health Club Services Act. And with that, we'll see if there are Q&A associated with this presentation. I hope you have found it helpful. And with that, Lorraine, I'll turn it back to you.
Okay. Thank you, John. We appreciate your guidance and expertise in this information. If everybody will get together with your state chair and regional chair and communicate as to your next steps, come together with your group. If you will keep us in the loop and let us know how we can help provide resources for you, whether it be sample letters or attachments or different invitations or samples of what usually works within the legislature, please let us know. We appreciate your time, John, and thank you to all the member clubs who could join us, and we appreciate everybody's time on this important issue. Thank you.